Hey gang, Stephen Marshall, KYLandlordlaw.com, back with another update. And if you feel like you've been in a bar fight for the last 2 weeks, I get it. We've gotten a punch from the governor, a jab from the Kentucky Supreme Court, and now a right hook out of nowhere from the president and the Center for Disease Control. It's all enough to make landlords want to throw in the towel and sell their properties. But for those of you who are still hanging in there, here's the latest. Tuesday, the Center for Disease Control issued an administrative regulation that most of you have heard about and been asking about. That regulation is going to have the effect of law, and it bans certain evictions for the remainder of 2020. Now, the purpose for the order is to prevent the spread of COVID-19, and it's based on a law created in 1944 that gives the executive branch broad discretion to take steps to prevent communicable disease. But here's the details of that new regulation. So first, it prohibits any landlord, any residential landlord, from evicting a covered person for non-payment of rent or other similar housing-related payments, including late fees, penalties, and interest. Now, the details are very important here. It prohibits landlords from evicting. The word evict is defined as any action by a landlord to remove or cause the removal of a covered person from residential premises. So any attempt that a landlord makes to remove someone is considered evicting them. That will matter, I think, going forward. What's a covered person? Well, it's defined as a tenant or a resident who provides a declaration under penalty of perjury indicating the following things. Okay, so your tenant has to swear under penalty of perjury that the following things are true. And if they do that, you cannot evict them for non-payment of rent. So here's what they have to swear to. Number one, that they have used their best efforts to obtain all available government assistance for rent or housing. That's number one. Number two, that they expect to earn no more than $99,000 in income during 2020 or $198,000 if filing a joint tax return, or that they were not required to report any income in 2019, or three, that they received a stimulus payment. Any of those three. Third, they have to certify that they are unable to pay the full rent or make a full payment due to substantial loss of household income, loss of compensable hours of work or wages, that they were laid off, or that they have incurred extraordinary out-of-pocket medical expenses. So that's the fourth thing they have to certify. Fifth, they have to certify that they are using their best efforts to make timely partial payments that are as close to the full payment as their circumstances permit, taking into account other non-discretionary expenses. And then finally, they have to certify that the eviction would likely render them homeless or force them to move into and live in close quarters in a new shared living arrangement because they have no other available housing options. So, if a tenant certifies that all those things are true, a landlord cannot take any action to remove them for failure to pay rent for the rest of 2020, according to the CDC. And the CDC has created a declaration form that tenants are to use to make this declaration. Now, the CDC's regulation makes it clear that the tenants are not relieved from their obligation to pay rent or other payments under the lease, including late fees, penalties, or interest. It's very interesting that the CDC order basically allows landlords to do exactly the opposite of what the governor's order last week allowed or prohibited them from doing, which was collecting late fees, penalties, and interest. So under the CDC order, you're still allowed to go after those amounts, and the tenants are still required to pay them. Fourth aspect of the order, you may still evict tenants for engaging in criminal activity on the premises, threatening the health or safety of other residents, damaging or posing an immediate risk of damage to the property, violating any applicable building code, health ordinance, or other regulation related to health and safety, or violating any other lease obligations other than the timely payment of rent. So this prohibition on evictions for covered tenants is only for non-payment of rent, okay, or any other housing related payment. It's scheduled to take effect tomorrow. That's Friday, September the 4th. It officially takes effect when it's published in the Federal Register, but that's expected to be done tomorrow, which is Friday, September the 4th. So those are the highlights. Those are the main aspects of the order. And so the question is, where do we go from here? And I'm going to give you the God's honest truth. No one knows. Okay? I'm telling you this as an attorney who likes to be clear, who likes to be honest, and who likes to provide actual answers. Okay? No one knows. I've been to court all week, and each day in court is different from the last. Okay? The judges are trying to figure out how to deal with the most recent orders from the governor, from the Supreme Court, and every single tenant is coming in claiming some type of COVID-related emergency. So simply put, that's where we are right now. I can tell you which eviction cases should theoretically go forward and prevail, but I cannot tell you in practice with any kind of certainty how any particular case is going to be ruled on if challenged. And if someone else tells you they can predict it, it's simply because they don't know what they don't know. Okay? Now, that said, we hope to have some answers soon. The Kentucky Supreme Court had some lengthy meetings yesterday working on a new order in response to the CDC regulation, and I expect that order to be out by the end of this week, and it should give us some sense of how our state courts are going to implement the CDC regulation that I described earlier. And I'll share that as soon as it's available. But you just need to understand that even though the Supreme Court directs the local courts to act in a certain way, we cannot guarantee how any particular judge is going to act. Only time is going to tell that. But as that information becomes available, we'll share that so that you can make good, informed decisions. But as of this moment right now, no one knows. We don't know what's going to happen to cases that are already filed, that are going to be heard tomorrow. We don't know if writs are going to be granted next week. We don't know if cases that are scheduled in the weeks to come are going to move forward. We simply don't know. And as of this moment, I don't think anyone knows. So this is an absolutely uncertain time. That's the only certainty as of this moment. But I did want to address one question that I keep getting asked due to these issues, and that's, should I change my leases to month so that I can just non-renew the leases of tenants who don't pay and potentially get around the eviction moratorium that way? And my thought is, there's no doubt that month-to-month leases give you more flexibility to remove problem tenants. Okay? That flexibility, however, is not absolute. And contrary to popular belief, you still need a legitimate business reason to remove a tenant, even if they're month-to-month, even if their lease is expired. For covered tenants under the CDC regulation, that reason cannot be non-payment of rent. So it's going to have to be some other legitimate reason, such as rules violation or your intent to sell the property, and then you're actually going to have to actually try to sell it. I've got an article on the site that goes into great detail into the issues involved in non-renewing a lease or a month-to-month tenancy. But the bottom line is, you're not going to be able to non-renew a lease or a month-to-month tenancy on the basis of the tenant's failure to pay and then be able to evict to get around the CDC regulation. That is my prediction, because that's how the judges were ruling on that issue back when the courts opened up in June. So there's always a balance between flexibility and security. Month-to-month leases give you more flexibility to get rid of non-paying tenants, but they do not give you much security, because the tenant can terminate those leases as well by giving you 30 days notice before the end of the next month. Now, it is somewhat the case that security is out the window anyway. If you're not allowed to evict, tenants, you don't have any security that they're going to pay. So you may want to go to the month-to-month lease because of the flexibility it gives you. Just please understand, it doesn't give you absolute flexibility, and it may open you up to a potential retaliatory eviction claim or a housing discrimination claim if you don't have a legitimate reason to non-renew the lease that's not related to the failure to pay rent. So check out the article on the blog for a little more information on that. I know that's a lot to process, and right now we have more questions than we have answers. But that's what I know for now. And sometimes the thing that you need to understand is that we just don't know, and that's basically the case on most of this eviction stuff right now. But as always, I will update you as things develop, and things will develop. We should have an order from the Kentucky Supreme Court later this week, and then as things move forward and I see how that's being implemented, I'll let you know that as well. And the last thing I wanted to tell you, just remember, as always, this too shall pass. Hang in there, okay? Be stronger than what life throws at you, and I'm confident that you can. Have a great day.